right, so we're back to House Judiciary Committee this Tuesday morning, May 19th, looking at a Senate proposed amendment to H642, the Act relating to youthful offender proceedings. And we have Legislative Council going to go over what they have wrought.
Yes, good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to let the committee know what changes the Senate made to H642, the House bill, an act relating to youthful offender proceedings. You will have a version in front of you that probably, hopefully says at the very top, Senate changes to House bill. So that in highlights, you will see where the changes are. You'll notice that there are very few of them. The bill as it came out of the House, you may recall, basically provided the ability of the court to extend jurisdiction, because ordinarily the court's jurisdiction over a young person ends at age 22. But the situation that the committee had heard testimony about is that sometimes when a young person violates their probation and they're near the age of 22, the court really doesn't have much authority or ability to impose conditions upon the person that are going to last very long, because they're going to age out pretty soon on their 22nd birthday. So what passed what you passed was the ability of the court to extend its jurisdiction beyond age 22 to deal with a probation violation motion that gets filed against the youth. So otherwise, so the court doesn't lose jurisdiction. They can still impose conditions. They can send the young person back to the criminal division, whatever it is they decide ought to be done. At least they'll have the jurisdiction to do it. So just that's, and there you'll see that's the very first change, or not change, but it is actually, that's the very first element of the bill on page 1. Over on page 2. The only change made, which you see that highlighted on line 18, is the corrected a cross-reference. So it's the only change there. Other than that, it's the same. Continuing down page 2 and page 3, this is the piece that provides that the court makes a decision about whether or not there are two sort of decision points for the court in this youthful offender process. The first one is called the youthful offender consideration year. And that's the point at the proceedings where the court decides, well, should this young person be treated as a youthful offender or not? Should it get that special status, those special proceedings? Or should it go back to the criminal division and treat the person as an adult? And subdivision 2, bottom of page 2, over on the top of page 3, at least through line 5, specifies some criteria that would go into this court's decision after a probation violation. So in other words, you're past the point where they've done the consideration hearing. The court said, okay, appropriate to have this young person be a youthful offender. Then they have a disposition hearing. That's hearing number 2. Disposition hearing is when the court imposes probation conditions. Says, okay, here's what your case plan is going to be. As a youthful offender, you're going to have to, comply with conditions A, B, and C, whatever they may be. Various elements to it that would be set out and spelled out in the case plan. But if the young person violates their probation conditions, then they are brought back into court, and the court has to decide, and well, all right, should you stay being treated as a youthful offender, or perhaps might it be better to send you back to the criminal division for treatment as an adult? Subdivision 2, which came out of this committee unchanged by the Senate, is some items for the court to consider when it's making that decision. In other words, the young person's violated probation. What should the court do? List these things for the court to consider, and it's actually very, very close to the criteria that the court considers when they're first deciding at that consideration hearing that I mentioned. Should the young person be treated as a youthful offender in the first place? So it makes sense. It's kind of like they're saying, all right, now that you violated, should you continue to get this youthful offender treatment or not? Last provision, page 3, also unchanged, subsection D. That's it. What if the young person fails to appear at this probation revocation hearing? In other words, they violated their terms of probation. They don't show up at the hearing. Well, then the court can order an officer to pick up the youth and bring the youth to court. An authority that exists under the juvenile law already, but just cross-references it and says the court can use that authority. The officer can use that authority to bring that person to court if they haven't turned up. So no changes there either. Last piece is section 2. This has to do with a separate issue, which is the rights of victims in youthful offender proceedings. Now, again, as I mentioned in these 2 hearings, right? There's the consideration hearing and the disposition hearing. Right now, under existing law, the victim has the right to appear and be heard at the second hearing, the disposition hearing. That's the hearing where they decide whether or not what the conditions ought to be, what probation conditions that you thought to be complying with. For example, it could be no contact with certain people. It could be going to counseling, whatever it may be. The court decides what those are, put it in the case plan and sets it. So under existing law, the victim has a right to appear at that proceeding and make their opinion known about what the case plan should include. For example, conditions of probation ought to be. The proposal as it came out of this committee and out of the House was to also allow the victim to appear and express their views at the consideration hearing. That first hearing, the hearing before the disposition, when the court's making a decision about, well, should this person be treated as a youthful offender in the first place, or should it stay in the criminal division? And the change the Senate made here was that in their perspective, that was a legal decision for the court, whether or not the person should be treated as a youthful offender or not. And at that stage, it is appropriate for the victim to be there and could certainly be notified of the hearing so they could attend, but that their perspective on that was not something that the court should be considering at that point because that was a legal decision. So that was the change they made. The victim is still notified of it and can be there, but they removed the ability of the victim to, or the requirement that the court consider the victim's views.
So before you jump to the next paragraph, it kind of deals with some of that same stuff. Can I ask a couple questions first on this paragraph that you're on right now?
Sure, but I could agree. The second paragraph is exactly the same thing as I just said. It's the same.
It does the same, right?
Yeah, same thing.
So reading the language on line 11 and 12 on page 4, to attend the hearing on the motion, consider youthful offender status and the disposition hearing. After that, the to present a victim impact statement, is that only modify the disposition hearing or does that also modify the consideration hearing? The way I read it is that they get to provide a victim impact statement for either or.
I think the perception was that it modified disposition hearing only.
That's not clear. So I guess that's not clear to me, that except that obviously when you keep on going at the very end, only with disposition. So
Right,
isn't the disposition is an order by the court, is that not legal as well? I don't know how that is different than the determination. I mean, they're saying, oh, well, that's a legal decision on whether to put the person into youthful offender status. The disposition is a legal decision too, is it not?
I think they felt that it was different. So it's a policy decision for you guys. You can have someone from their committee come in and talk about that, but
it's different, but it's still, I mean, the court was making that decision. Yeah, okay, the decision is different, but so did they consider the factor of, and this is maybe a question for them, don't answer it if you can, of course, that one of the criteria for determining whether to put somebody to youthful offender status is the public safety will be protected. And that's presumably what the victim could be providing an impact statement for, to talk about public safety. Did they consider that?
I don't recall.
Okay,
specifically.
Yeah, and I can ask, I'll ask Nod on that. And here's one last very important thing. Line 14, shouldn't the
Page.
on page 4,
Yep.
After and, shouldn't that be a semicolon, not a?
That's what I was thinking too. Is that the top of my list?
Which one?
What do you think?
Where?
Line
That's
14,
Angela, who's,
comma after the struck out and. Looks like that should be a semicolon. Because the next line, it says semicolon, the youth including test, comma, the youth, and then there's another semicolon and.
it's a list within a list.
It's a list within a
you usually
list.
need a semicolon.
Wow.
So right there is a reason for us to send this to conference committee. Yeah.
Drafting might be hiring.
Well, Eric might disagree ultimately, but-
Let's see.
or the drafter might.
No, I'm just wondering about the language after that. Is that separate? Is that a separate component of the list within the list, or is that related to the offense?
It's,
Express reason with the victim's use concerning the offense. Yeah, concerning the offense.
Oh, the
the
youth. Yeah, not a list within a list.
it's not?
No, because the youth, it's a comma. The offense, the youth.
So why do we have then line 16, that semicolon needs to be a comma?
No, because that's where that clause ends, I think, on line 16 after restitution. But you do need another and. The victim
Yeah,
accused concerning the offense, the union and.
So I think maybe the and should have stayed in there.
Yeah, the and,
Yes.
or the and should stay, one of the,
Right.
okay, I'm fine with the and staying, I
Yes.
think we might
Yes.
affection about this.
That's the right, that's the.
So, all right, so
And I don't know this for sure, but this is like giving me deja vu. So that's making me think, did somebody catch this in the editorial process and it was fixed as it passed the Senate? I just didn't fix it in my Senate changes to House bill document.
oh, I see, okay.
But
Yeah.
I'll follow up on that and find out. Either way, I don't think that's not determinative of what you're going to do, probably.
There's some sort of policy issue with, I
Right.
think very much this committee wanted to include some input from victims for determining youthful offender status. Now, the question is, do we go back to our language and send it back over, or do we ask for a committee of conference? Yeah, Karen and then Ian.
I would suggest a committee of conference because it seems like it's kind of two different viewpoints and we don't have time to go back and forth for all that to decide that. So I think a committee of conference could find the common ground and hopefully move this bill forward. There's certainly not time to go back and forth. I think committee of conference would be the most likely path.
Or it might be,
Unless,
I'm told not.
well, the other path is if I can talk to the Chair Hashim and see if we changed it back, that whether they would concur, but that probably,
I think that would just be a committee. That's the conversation right there.
right, okay, all right, yeah, Ian.
Yeah, community conference makes more sense. And I think the distinction as to whether the victim impact statement is being considered for a legal decision or not is, I don't even understand that, to be quite honest, because anything you're letting the court consider the victim impact statement as part of their decision making is a legal decision. And we do have places in law where we don't have the court actually take into account the victim impact statement. We let the court hear it, but they're not allowed to consider it. So if they wanted to do that, they could have done that, but instead they're drawing this kind of.
Yeah. Okay, so
Can I make a motion?
You are.
yeah, go for it.
I move that we submit. You said I could.
It's just that I think I probably should talk to the chair to tell him where we're coming in case he can just agree. It's just the way we try to do this, so we don't have any surprises. So we're gonna be meeting again to take a vote on that.
We're gonna get in trouble.
You don't even know. You don't even know what I was gonna move.
I think I know what we're gonna move. So we'll meet 5 minutes before the floor and have a quick vote on that. But I just need to give them a heads up
So
before.
12:55.
12:55. All right, so any questions for Eric other than that on this? So thank you very much.
You bet.